RadioShack put a sign up in its shops. We respect your privacy. We do not sell our mailing list. The information you give us is treated with discretion and respect. We pride ourselves on not selling our private mailing list. We know the exact words of that sign for one reason. In 2015, the Attorney General of Texas filed it in a bankruptcy court as an exhibit. He filed it to stop RadioShack selling the mailing list. The only reason the promise survives is that somebody needed evidence it had been made. That is the film, a sentence written in a shop and a duty written in a statute on a collision course for 20 years, and nobody noticed until the receiver arrived. Start with what was actually collected. The Federal Trade Commission, writing to the court, listed it. Name, physical mailing address, telephone number, email address, credit or debit card number, and purchase history. For over 117 million customers. There is a footnote to that letter, and the footnote is the sharpest thing in the whole document. Purchase history was kept for 3 years, unless the customer bought a service plan or a warranty, in which case it was kept indefinitely. Read that again. Buy the batteries, they forget you in 3 years. Buy the protection plan and they remember you forever. There is something almost tender about it. You bought the warranty because you wanted the thing to last, and it did, just not the thing you meant. We're not going to tell you what the checkout felt like. There are stories about that. Most of them are a Seinfeld routine, and one of the most cited articles about it turns out to be satire with invented analysts in it. The documents are better anyway. So, why was there a bankruptcy at all? The easy version is that RadioShack stopped being a shop and became a phone counter, and the number people quote is real. By 2013, mobile was 52.4% of everything the company sold. $1.8 billion out of $3.4. The store that taught America to solder was, by revenue, mostly a place to sign a phone contract. Except that reading is wrong, and the audited filings say so. Look at what the carriers actually paid. Commission and residual income from the phone companies. $1,233 million in 2011, $1,029 million in 2012, $851 million in 2013. That is not a business taking over. That is a business falling 31% in 2 years. Mobile's share went up because retail was collapsing faster. The phone counter was not the strategy eating the company. It was the last part still paying, and it was shrinking too. And the company knew exactly what was killing it. From its own annual report, sales declines in laptop computers, cameras, music players, GPS devices, home entertainment accessories, televisions, and personal computer accessories. The decrease in sales for many of these categories has been driven by the migration of the capabilities of these products into smartphones. That is a company writing its own cause of death in the passive voice. Everything we sell is now one object, and we are the shop that sells you the object for a commission from somebody else. February the 5th, 2015, Chapter 11. And here is where the film stops being about a shop and starts being about a machine. When a company files, its management usually stays in place. The law calls that a debtor in possession, and it hands them the powers and the duties of a trustee. They become a fiduciary, not to you, to the estate and through it to the creditors. There is a line in the bankruptcy code that puts the idea at its plainest. Collect and reduce to money the property of the estate. That line is a Chapter 7, trustee's duty, and I want to be precise about it because the tempting version of this story is that a statute forced RadioShack to sell your data, and that is not true. No provision ordered it. What is true is quieter and worse. The estate was a fiduciary. The customer file was, by then, one of the most valuable things left. And a fiduciary who declines to monetize a valuable asset is failing the people it now works for. 10,000 jobs went with the sale. Trade creditors were owed real money. Nobody had to be told to try. The law obliged them to try. And nobody in the building had a reason to say no, so they marketed it. The customer records went into a motion to sell the intellectual property. And here the story does something I did not expect. It runs into a tripwire that Congress put there on purpose. Section 363 of the Code is the ordinary machinery for selling things in a bankruptcy. But if the company promised its customers it would not transfer their information, and that promise was in force when the case was filed, the estate may not sell it, unless the sale is consistent with the promise, which this one plainly was not, or unless the court appoints a Consumer Privacy Ombudsman, holds a hearing and approves it. That office did not exist when the sign went up. It was created in 2005. The sign did not stop the sale. It changed which door the sale had to walk through. It is worth sitting with how ordinary that machinery is. A Section 363 sale is how almost everything gets sold out of a bankruptcy. The shelving, the leases, the trademarks. A court gives notice, holds a hearing, and property changes hands, and the whole point of the procedure is that it is fast and it is not sentimental. RadioShack had already been through it once that spring. The stores themselves went in April, about 1,750 of them, to a buyer that kept roughly 10,000 people employed. Nobody wrote a think piece about the shelving, and the customer file went into the same pipe as the shelving, in a motion about intellectual property, because in the accounting of an estate that is exactly what it is, an asset of uncertain value, sitting between the trademarks and the fixtures. RadioShack itself told the regulator the file might not even be much good. Many of the data entries, it said, may be duplicates or not current. That is the sentence a company writes about the thing it is trying to sell you. Here is what went through the door. The databases held about 117 million records. What was actually offered was smaller, and you will not read this anywhere, approximately 67 million complete name and address files. Around 8.3 million of those had an email attached, and the transaction history came in 21 fields. Which brings us to the thing that happened 5 years earlier to a company selling toys. ToysMart promised its customers it would never share their personal information. ToysMart went bankrupt. ToysMart tried to auction the list. 44 states and the Federal Trade Commission objected, and in the end a Disney subsidiary paid $50,000 to have the list destroyed. 250,000 people bought and deleted. $50,000 to make a list stop existing. That case is the reason the Ombudsman's office exists at all. And in the RadioShack settlement, the parties agreed that the sale order would not contain a reference to inretoysmart.com. I am going to state that and leave it alone, because why they wanted it out of the paperwork is not in any document I can show you. What ToysMart did leave behind was a template. The Federal Trade Commission settled that case on 4 conditions, and they are worth hearing, because they are the conditions it went on to recommend for RadioShack 15 years later. The list could not be sold on its own, only as part of the business. The buyer had to be in the same line of business. The buyer had to be bound by the promise the original company made, and any material change to that promise needed the customer to say yes, actively. The Attorney General of New York put the principle more bluntly at the time. Private consumer information, he said, is not an asset to be sold to the highest bidder. That is a quotable line from 2001, and the reason we are still here is that it describes a rule nobody ever quite wrote down. So, the mediation, 3 days in May, and it produced the number this whole film is built on. They asked for 21 fields of your transaction history. They left with 7, store number, ticket date and time, the SKU number, its description, its price, how you paid, and how much. That is what a buyer got. 14 fields were negotiated away, and their names are in the document, and they are magnificent. Register number, ticket number, operator initials, sales associate initials, ticket subtotal, ticket tax percentage, transaction-specific legalese text. Somewhere in a room in May 2015, adults with law degrees argued for 3 days about whether a stranger could buy the initials of the person who served you. Now the part that a film like this is supposed to skip, the case for the other side, at full strength. The duty was real law, not a euphemism for greed. The creditors were real. About 10,000 people kept their jobs because somebody bought the stores. The databases did not contain social security numbers or dates of birth, whatever you have read elsewhere. Card numbers were masked after 120 days. Phone numbers were never transferred at all. The bulk of the data was withheld and ordered destroyed, with an initial certification filed with the court and later ones delivered to the Ombudsman. And the buyer did not simply get the file to do as it liked with. It took the data bound by RadioShack's own privacy policy, which forbids selling it on. Changing that materially required customers to opt in actively. There was an opt-out by email, by post, online, and by a free phone number. If a notice came back undeliverable, the record was destroyed, and nobody was ever found to have broken anything. The Federal Trade Commission's letter was advisory. Its own press release calls it recommended conditions. There is no ruling here, no finding, no villain, which leaves a narrower claim, and I think a more unsettling one. Not that anyone lied. That a sentence written in a shop to reassure somebody buying a battery and a duty written in a statute to protect people owed money were pointed at each other for 20 years, and the first time anyone put them in the same room was a bankruptcy hearing. The tally. Records held 117 million. Records offered 67 million. Transaction fields offered 21. Fields taken 7. States that objected 38. Phone numbers transferred none. Findings of wrongdoing none. And the sign still quoted in a court filing because that is the only place a promise like that ends up being written down. A privacy policy is not a vow. It is a statement of current intent by an organisation that can be dissolved. And when it is dissolved, everything it holds becomes a line item. The sign was never a lie. It just had an expiry date nobody printed on it. Some deck. There's always another one.